Good morning, you're Brianne Williams?
Yes, ma'am.
And this is cause numbers 26 DCCR, excuse me, 0531. Ms. Williams entered a plea of guilty in that case to a new offense of possession of a controlled substance, a third-degree felony. And then we've got cause number 1830512. Ms. Williams is on probation for injury to a child, and that's a third-degree felony offense. Entered pleas of true. Let's see, I see where. While I look at that, but there was an agreement, it appears, for a 3-year deferred probation, $500 fine, and ISF substance abuse track on the new case with continuing probation and ordering substance abuse, ISF substance abuse on that one. I've received the pre-sentence report and gone over it. Have y'all both had an opportunity to review that report?
Yes, Sharon.
Yes, Jeff.
Let me go back and look at something. All right, so it was a 10-year deferred probation from May 20th, 2019 for that injury to a child or elderly, excuse me, individual. And it looks like she pled true to counts 1 through 5, which include that new offense of failure to identify, a new offense of public intoxication, being an out past curfew, and court assessed fees. So I guess what I have a question mark here and an issue and a question, which is why is it just 3 years on a third degree felony possession when we've already got a 10-year deferred on the other one? I just don't know that that makes sense to me for it to be that low of a number of years for a new offense while you're on a felony offense. I'm not opposed to the ISF and do it and going forward with probation, but I just don't think it makes sense to do
It could have been the length of time.
That she had already been.
Right, because the new case, the new offense was from 2024, did not get indicted until this year. So I think that played a part
okay.
in it.
But it was okay. But it still was after she was on probation.
Yes,
but it didn't get indicted for
and
a
I
long time.
believe when it originally occurred, that was addressed at a previous MTRP hearing, but it did not get indicted till 2 years later.
Okay. All right. Anything else then?
No, Your Honor.
No.
All right, Ms. Williams, with that explanation, I'm going to follow the agreements that you made with the district attorney's office. And cause number 26 DCCR 0531, find sufficient evidence to find you guilty. However, I'm going to follow that agreement and in that case, defer all proceedings and place you on probation for 3 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation, which includes entering and successfully completing the substance abuse track of the of ISF. And then in cause number 18-30512, I'm going to find that you enter those pleas of true to counts 1 through 5 freely and voluntarily, find those counts true, find sufficient evidence to find you guilty and revoke your probation in that case. But I'm not going to do that. I'm going to follow the agreement, continue you on probation, order as a condition of that probation that you enter and successfully complete the ISF substance abuse track as well. You're being given now all the opportunities that you're probably going to be given. So you're going to go to ISF. You'll get the tools you need in order to remain sober. When you get out, you'll have aftercare. You still have no felony convictions. You still got some great opportunities here to kind of get your life back on track, get off drugs, and just live a normal life. If you don't do that and you don't take advantage of this and you continue to test positive and do the things that you did on this one, you're going to end up back in here and you could go to prison in each of these cases for up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certifications in each of those cases that shows that these were agreements that I followed, and so you waived your right to appeal. Good luck to you, ma'am.
Yes, ma'am. Thank you, Judge.
You have worked out with Mr. Kimler
Yeah,
agreements in both cases,
Yes.
correct?
I'm not sure, did Mr. Cameron do it? Discover?
Yes, ma'am.
Okay.
Let's see, this is, Ms. Malfino's on Ms. Clemens. And you got the other.
Two cases.
All right, ma'am, are you LaAsia Clemens? And Ms. Clemens, Mr. Pimler represents you in one of your cases. Ms. Holmes represents you in the other. It's my understanding you've talked with both of them this morning and have agreements with regard to pleading guilty in your cases. And are you okay going forward with just Ms. Holmes going through this paperwork and stuff with you? Okay. Will your client waive the formal reading of the indictment in each case?
Yes, Your Honor.
Right, Ms. Clemens, in cause number 26, DCCR 1179, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from May 20th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? And then in cause number 25, DCCR 1339, you are charged with the second-degree felony offense of robbery from September 9th of 2025. And how do you plead to that charge? Again, are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? In each of these cases, I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes and or Mr. Pimler? Do you fully understand them? And do you understand if I follow the agreements that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached in each case is for a 5-year deferred probation in each of your cases. There would be a $500 fine in each case, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? You also understand, if you're not a U.S. citizen, that
Notice how every guilty plea includes a warning about possible immigration consequences. Even when someone is a U.S. citizen, judges routinely give this advisement because it's legally required. It's one of those courtroom procedures that happens so often many people don't realize how significant it can be. Instead of sentencing immediately, the judge wants more information through a pre-sentence investigation. That's often a sign the court is looking beyond the charge itself, examining the defendant's background, risk level, and chances of succeeding on probation. Do you think gathering more information leads to fairer sentences, or does it sometimes delay justice?